Holy God. You know.
Ladies and gentlemen, this is Olayemi Dear Kolola Daniels, popularly known as Dear Spectre, and this is another episode of Dear Talks Law. And today we'll be talking about company law, specifically corporate political activism. Corporate political activism, and we'll be talking about the meaning, the reason for the CPA, speaking for and against, and also the CPA under the Constitution, the Cama, as well as the Electoral Act. And we'll also be looking at the CPA in the United States, effect of the CPA on Nigeria, and lastly, recommendations. So without further ado, I'll be moving straight into what exactly the CPA means. When we are talking about the meaning of the CPA, which is the Corporate Political Activism, we're asking the question, can companies participate in politics? Now, can companies, 1, participate, 2, in politics, 3, those three things that I've highlighted are very, very important, and we are going to see it unveiled under the under the CPA, under Constitution, Cama, and the rest. We're going to see the three things that I've spoken about unveiled there. But what we should have in mind right now is the question, can companies participate in politics? And now we are moving into the second one, which is the reason for the CPA. Why exactly, the reason, why exactly do we have CPA? When I mean CPA, I mean corporate political activism. So why exactly do we need to have the CPA? So I'm going to start with those that go for the CPA. So those that argue for the CPA, they say we need to have the CPA because number one, influence. Number one, influence. So now, when you have a company in a particular country, the company cannot thrive in business when the laws in that company are restricting the company's business. So the company needs to make sure that the lawmakers as well as the executive are on their side, so that the laws which they will be making will be to help their business. Because let's face fact, companies are created for business, except those that are created and limited by guarantee, those ones which are created for the continuance of education, for this and that. But I'm talking about company limited by shares. They are created for profit making, and then when the laws in a particular country is so stringent that it goes against the essence of their creation, which is business and profit making, those companies will tend to leave that particular country and go to another country. And then we are talking about a country like Nigeria that needs the economy to be better, and so we have to make sure that the laws that are being made are company friendly. Do you understand? The laws that are being made are company friendly, and so the only way we can have that is when those companies can influence the lawmakers to make law to their advantage. So yes, so that is the first reason that they made, which is influence. Now the second reason is freedom of association and expression. Freedom of association and expression. These are two rights in the Constitution. And then, okay, so now that we have spoken about influence here, now we have to move to freedom of association and expression. And then the question we ask is, can a company have freedom of association and expression? We have to start from section 37. And section 37 says that once a company has been registered, the company is different from the members. And then section 38(1) says that the company shall have the power of a natural person of full capacity, which means the company shall enjoy the rights of a natural person of full capacity. And then if you have watched the video of Yusuf Oluwafemi Salako, in his video titled "Can a Company Participate in Politics?" Femi Salako said that although he's agreeing with the fact that these rights are derogable according to Section 5, according to Section 45 sub 1 of the Constitution, these rights are derogable. And let us, go to Section 45 sub 1 of the Constitution so that we can fully understand what Femi Salako was saying. Now, according to Section 45 sub 1, it says nothing in Section 37, Section 38, Section 39, 40, and 41 of this Constitution shall invalidate any law that is reasonably justifiable in a democratic society. A. In the interest of defense, public safety, public order, public morality, or public health. And according to the submission of my learned brother Femi Salako, he said that this restricting the corporate political activism does not fall under any of this. You understand? And so he thinks that it is not right that corporate political activism is being restricted, especially in Nigeria, as it doesn't fall under public morality. It doesn't fall under public morality, public order, defense. It doesn't fall under public morality, public order, defense, public safety, and public health. Public safety and public health. But I beg to differ on the ground that it falls under public order. The fact that corporate political activism has been banned in Nigeria, thereby restricting their right to freedom of association and freedom of expression, falls under public order. And then the question is why? I would answer that question by stating, number one, corruption. You see, when we tend to give these companies, the liberty to do whatever they want to do, and then we tell them that they can go into public activism, which means that they can, donate money, contribute money to political parties, what would tend to happen is that those elected officials, when they finally get elected, for example, if company A donates money to political party B, and political party B has a candidate C, company A donates money to political party B, and political party B has a candidate C. Now, this candidate C becomes the president of the country, and then company A during the campaign gave political party B 50 billion naira. Now, when President C becomes the president of the country, don't you think that the first thing is that President C is indebted to political party A, and therefore the policies, the laws, and money that would be accruing to the federation account would some way somehow be finding its way into company A's pockets? Because now that President C has entered, company A gave President C money. President C definitely would be indebted to company A, and so the laws which the president would be passing, the money accruing into the federation account would one way or the other find itself into the coffers of this particular company, and therefore that is going to affect the masses that are at the bottom of the barrel. The masses at the bottom of the barrel will be the ones to suffer it, and therefore public order will therefore not be maintained in this circumstance. And so this is the reason why the corporate political activism is banned, or this is one of the reasons against banning corporate political activism. Now, the second reason would be interest of minority. The second reason here would be the interest of minority. So we are saying that when you have a company cannot exist without shareholders. So when you have a company and you have the minority shareholders and then the majority shareholders, I know that there's a saying in company law that the majority have their way but minority have their say. However, However, when the minority was given its parts, its money as share capital, the minority was given that money in order to further the company's objective, and not for the company to be participating in politics or contributing money to a particular political objective that the minority does not even share in the first place. So here you are trying to protect the interest of the minority. I am a minority shareholder in a company and I want to support, I'm giving this as a very rough example, I want to support Showore, and then the company wants to support Atiku. But me, I am supporting Showore. Now, my money that I've given to the company and every other thing that I've given to the company would be used to further Atiku's campaign. That is going to be, injustice to me. It's not going to be fair to me. And so we have to, in total, block the corporate political activism and restrict it totally. And so now we are moving to the next part, which is the corporate political activism under the Cama, under the Constitution, as well as the Electoral Act. Okay, so now that we have gone through the reason for the CPA, before we start this, I want to advise that get a copy of the Cama, you get a copy of the Constitution as well as the Electoral Act, because they are going to be very important as we scrutinize the three of them. And now that we are talking about Cama, we are saying, is the corporate political activism, is it banned under the Cama, yes or no? And that's the question that we are about to ask right now. So the first place we have to go to is section 38(1). So we have to start with section 38(1). So now, when we get to section 38(1), don't forget that I said earlier that a company shall have the power of a natural person of full capacity to further its objects. So a company has power of full person, or power of person of full capacity, same thing. Now, when a company has the power of person of full capacity, the only time this can be restricted would be in two instances. The first one is by the memo. You can restrict the power of a company by the memo, and that can be seen in section 27(1). Do you understand? You can restrict the power of a company by the memo. Now, another way to restrict the power of a company would be by any other enactment. Any other enactment. Now, an enactment is a law. I'm very sure we all know that. So let us read section 38(1). Now, except to the extent of the company's memorandum or any enactment otherwise provides, every company shall, for the furtherance of its authorized business or object, have all powers of natural person of full capacity. Now, the act already says any enactment, and we don't have to argue that Cama falls under any enactment in this instance. So now, when we go to under the any enactment, we go to section 38(2). Section 38(2). Now, section 38(2) says that a company shall not have or exercise power, either directly or indirectly, to make a donation or gift of any of its property or funds to a political party or political association or for any political purpose. Okay, now, to understand this thing very well, the first thing we need to start from is who cannot make a donation. Who cannot do something, what can the person not do, and who should not receive this thing in question. Now, the first thing we have to start from, apparently we are talking about companies. So definitely, the first who here is companies. And note that companies here include that in section 26. The companies here include that in section 26. The ones in section 26 are restricted by guarantee. Do you understand? And I already explained to you earlier that when the company is set up for the main aim of advancing education, science, things and that. It is not for profit making. However, it is restricted by guarantee, and that falls under Part C of Cama. Now, so, and we're talking about these companies and the other companies restricted by shares, limited by shares, same thing. So now we are talking about when we are done with who, which means companies either limited by shares or limited by guarantee, falls under these parts. Now let us now go to what can't this company do. Do you understand? What can they do? Now according to the Cama, it says a company shall not, which makes it a mandatory provision, a company shall not have or exercise power directly or indirectly to make a donation or gift. A donation or a gift. To make a donation or a gift of any of its property or funds to a political party or political association or any political purpose. To political party or political purpose. Political party or political purpose. So you can see, a company shall not make a donation or gift to a political party or for any political purpose. Now it now begs the question, so if a company doesn't have the right to make a political donation to a political party, it means that a company can spend independently, that is independent expenditure for the furtherance of an objective. Now note that when I talk about objective, under company law there are two types of advocacy. You have express advocacy and then you have issue advocacy. So you have express advocacy, and then issue advocacy. So I don't want us to get confused in this circumstance, so I'm just going to give you an explanation. So let us say that a party, PDP and APC, I'm using these parties because they are the most familiar to us. So PDP and APC, as Nigeria operates a two-party system, jokingly. Now, PDP is pro-life, APC is pro-choice. Now, if we are conversant with abortion laws, we would know pro-life means that we should safeguard a fetus, no matter how little the fetus is. That fetus is a child and therefore should not be killed. Pro-choice is saying that the woman should have a choice whether or not she wants to have the baby and all that. So if we are saying APC is pro-life, APC pro-life, PDP pro-choice. Now, if a company in Nigeria set up as an hospital that does abortion, you will all know that that hospital cannot thrive in Nigeria because abortion in itself is illegal according to our criminal code, as it contradicts also section 33 of the Constitution. So abortion in itself is illegal. So, but let us look at a country and say that Nigeria is a country that, haven't made abortion laws. Which one do you think that a company would want to go for? A company that does abortion would want to vote for? That is pro-choice, definitely. So now, imagine that a company, knowing fully well that PDP is pro-choice and APC is pro-life, now decided to make donation to PDP for a political purpose of, advancing pro-choice. Is making donation to PDP for the political purpose of advancing pro-choice. Now, in this particular circumstance, it's going to be contravening section 38(2) of the Cama. Do you understand? But what if the company did not give a political party any money, but the company now decided that it set up a billboard and then write be pro-choice and not pro-life, or it decided to start sharing flyers to people and start saying, and on the flyers you have be pro-choice. It doesn't say vote for this person or vote for this particular political party. It's just advocating for the fact that you should be pro-choice and not pro-life. Do you understand? Now, in that particular circumstance, the company is expending money which is going to be independent expenditure on particular objective, which would be issue advocacy. Here it is not express advocacy because it is not expressly telling us to vote for a particular political party or a particular person, but is in fact advocating for a particular issue in the community. And in this circumstance, it will go through the provisions of the Cama very well. It doesn't restrict a company from independent expenditure on issue advocacy. All it does is restrict a company from making donation, gift or contribution to a political party for a political purpose. Now, it now begs the question that since a company cannot donate, because what the Cama expressly prohibits is a company donating money for political purpose. The question is, can a company expend money independently? Do you understand? He didn't give it. The company is not giving it to the political party, but the company is expending money for express advocacy, which is for a political party. So now, I did not hand the money over to PDP. There is no transfer alert to say, Dear Co and Co transferred 50 million naira to the People's Democratic Party. But I am in my own little way expending money, setting up billboards and all that for the advancement of PDP's agenda or PDP's candidates. Now the question is, in that circumstance, would I be contravening the provision of section 38(2) of Cama? That is, a place that is going to be a little bit difficult to answer, because at that point, I myself would submit, although it might be wrong, I myself would submit that yes, it would not be contravening the provisions of section 38(2). This particular part has not been spoken about in court. It has not been interpreted in court. So everything we can have at this point to just be mere opinions, and my own submission is based on the fact that the Cama was clear when it said the company shall not have the power to make donation or gifts. The company shall not have the power to make donation or give to a particular party for the furtherance of a political purpose. It didn't say that a company shall not spend money independently. If I don't donate or give gift to you a particular thing and I spent it though for you, but it didn't get to you, like the money wasn't given to you, the gift wasn't given to you, then I don't think it's going to be contravening the provision of section 38(2) in that particular circumstance. So I hope you have been able to understand company to donation, gift, which is the same as contribution, and also political parties. Now, company making expenditure, independent expenditure of, different from this on a particular issue. The fact that the company is making independent expenditure on issue advocacy is not even, a problem under section 38 of Cama. What might be a problem is company making independent expenditure to express advocacy. So now that we have spoken about the rigors of CPA under the Cama, let us go to the Constitution and even understand what the Constitution has to say on CPA. So now that we have spoken on Cama and we understand the whole express advocacy, issue advocacy, independent expenditure, donation and all that, let us look at the Constitution. What exactly does our Constitution say about the CPA? And let us go to section 221 of 1999 Constitution. So going to section 221 of the 1999 Constitution, it says no association. Let us do what we did the last time. So we said who, what, who. So who can give what to who, or who can't give what to who, as the case may be. So no association other than a political party shall canvass for votes. No association other than a political party shall canvass for votes. So here talking about canvassing for votes. Canvass for votes for any candidate at any election or contributes to the funds of any political party or to the election expenses of any candidate. So here you're talking about contribute for political party and candidate. Political party and candidate. If we look at section 229 of Constitution, it defines association to be both body corporate and incorporate. Obviously, it means that companies are here. So section 9 tells us that company falls under section 221 of the Constitution. So no company shall canvass and contribute. No company shall canvass and contribute. Do not forget that under the Cama, it says that it cannot donate or gift, which is contribute as well. You cannot donate or gift, but under the Constitution, you can't canvass or contribute to any political party or any political candidate. So now, first question, can the company have independent expenditure? Independent expenditure for issue and express advocacy. So now the first question, can the company have independent expenditure for issue advocacy? Did they say anything about issue here? No. Which means that a company can have independent expenditure for issue advocacy. The second question, can the company have independent expenditure for express advocacy? The answer is no, the company can't, because where you have independent expenditure for express advocacy here, you are canvassing for votes. So like Cama that says that you cannot gift or donate in that particular circumstances for a particular political party. In that situation, you can't gift or donate, but you can spend independently, or that is my own interpretation of that section. You can spend independently for a political party, but you can't just gift or donate to them, which is going to be express advocacy. But here you can't have express advocacy because your express advocacy will result to canvassing. So here you will be canvassing for a particular political party, which is going to be against section 221. However, you can have issue advocacy, as in the Constitution only said canvass or contribute. The Constitution did not say that you can't spend on a particular issue. In short, nothing like issue was mentioned in this section. The only place you will find issue advocacy would be in Cama, where it says for political purpose, which under it you can have issue advocacy. Abortion can fall under political purpose, as well as every other thing that can affect the object of a particular company. So now we have spoken about the Constitution, and we already understand that a company cannot canvass or contribute to any political party or its candidate, and it means that the company cannot have independent expenditure for express advocacy, but it can have independent expenditure for issue advocacy. Now let us go to Electoral Act. Electoral Act seems to be a little bit confusing. Section 90 Electoral Act 2010, which is pari material with Section 83 Electoral Act 2002, we are going to see that the Electoral Act seems to be giving a restriction to the amount of money that a company can give a political party. When we look at provisions of the Electoral Act, we would see that it could be implied that according to them, the CPA is not banned because it's only limited. Do you understand? So it means that companies can donate, but companies cannot donate above a particular amount. Now, we don't even need to go too deep into the Electoral Act because it is going to be in direct contravention of Section 221 of the Constitution. So we already know that according to the provisions of the Constitution, that is Section 1, subsection 3 of the Constitution, if any law is inconsistent with the provisions of this Constitution, the provision of the Constitution shall prevail, and that other law shall be null and void to the extent of its inconsistency. And therefore, to the extent of this inconsistency against the Section 221 of the Constitution, the Electoral Act shall be null and void, and therefore the Constitution will still prevail. So the question here now is, which will prevail? It doesn't even seem that there is a direct inconsistency between the Constitution and the Cama. Do you understand? But if there should be inconsistency in the interpretation, we should know that the Constitution would always prevail at every point. Now, we are about to move into the CPA according to the United States of America. How exactly have they been able to find their way around the CPA? So these are the 5 cases on the CPA in the United States of America. If you want to go into the jurisprudence of the CPA, then you can look up any of those 5 cases. Most importantly, look at the case of Buckley versus Beloy and also the case of McConnell versus Federal Electoral Commission. In both cases, they distinguished expenditure from contribution, and according to the Supreme Court of America, it said that one was in direct contravention of the First Amendment right of the citizens as well as the company, while the other was not. So you can just look it up and know what next. And let us go next to the effect of the CPA in Nigeria. So while we are talking about the effect of the CPA in Nigeria, we are saying that if we have an absolute ban on corporate political activism in Nigeria, then what will be the effect? The first thing we have to note is that it is quite impossible for us to have an absolute ban because of corruption. Nigeria is dipped into corruption. Everything about the existentiality of Nigeria is corruption. Nigeria cannot be removed from corruption, and therefore the fact that we have a law saying A does not mean that Nigeria is saying B, especially when the A is unrealistic to be practiced. The fact that you are putting an absolute ban on the CPA is very unrealistic and cannot be practiced to the letters in Nigeria. It only would give more room for corruption in Nigeria, and also we are not letting the companies have the opportunities to choose leaders that are going to thrive. The leaders that are going to make laws for the companies to thrive in the country. And so we have to ask ourselves the question, is the CPA for our good or for our bad? That's the effect that the CPA has on us as citizens. Is it good or for bad? Because in this circumstance, we are just opening the gate for more and more corrupt practices, as well as letting companies not have a friendly environment in Nigeria. So now we move into the recommendations, which is going to be the last thing we'll be talking about today. So lastly, while talking about the recommendations, we should look at these 3 recommendations for our CPA in Nigeria. Now, let us start with the first one, which is distinguishing between contributions and expenditure. Just like the United States of America, to put a total ban on the contribution a company should make to a political party would restrict freedom of expression and association. However, you can restrict the expenditure and say that a company cannot spend more than this particular amount during political years. that seems quite reasonable, quite understandable, so that companies can have their people in position of power that can make laws to their advantage. And also note that when the companies have been given restrictions or limitations to the amount they are to spend, they should always include it in the annual budget of the company, so that everybody in the company shall know that this particular company have expended this money on this particular thing. And if I am to support political party A and my company is supporting political party B, I want to see it in the company records that this company is supporting political party B. Do you understand? Instead of when the company does it without my knowledge. So in this particular circumstance, the company is doing it, and I'm making sure that the company is not passing the amount that has been limited for public donations. And then lastly, there should also be full disclosure to the public at large, so that when that particular candidate finally emerges as the winner and then becomes the head or is in the legislative house, where there are particular policies or this or that are being made, the public would be able to criticize the actions and understand when there is a quid pro quo between the political parties and the elected officials. Do not forget that the elected officials are supposed to serve the public at large and not just the political parties. So when the elected official is going to use his office as an engine for the favor of a particular political party because he contributed to him or her during election, then that would be against the tenets of democracy, apparently. So this is where I'll be rounding up on the lecture today on corporate political activism. I hope I've been able to answer questions, and if I have not been able to answer this or that question, you can interact with me on the comments, in the comment section down below, and make sure that you subscribe and like this video. And thank you very much for viewing. I am Olayemi Dear Olola Dana.
Oh, look up. That's good. Oh, look up. Set now. Oh,